My name is Captain Harley Maya, and I'm a legal assistance attorney here at Marine Corps Base Hawaii, Kaneohe Bay. This video is meant to provide you information about the military-specific aspects of divorce. Please have a pen and paper handy because I'm going to tell you specific resources to look up. It is important to note that watching this video does not make me your attorney. That would not happen until you came into the office, had a conflict check, and we discussed your case. If you are a husband and wife reviewing these materials together and you still have questions, our office can only see one of you. So between the two of you, decide who will come to the legal assistance office here on base and who will go to Pearl Harbor or another legal assistance office. The number for the main line of Pearl Harbor's legal assistance office is 808-473-4717. The topics I'm going to cover are 1. Family support requirements in the absence of a court order or separation agreement. 2. Considerations in dealing with on-base housing. 3. Early return of dependents. And 4. Extra considerations. Number 1. Support requirements for Marines and their spouses can be found in League Admin Man, Chapter 15. It states that in the absence of a court order or separation agreement, that Marines still owe support to their families. The amount that Marines owe can be calculated by looking at the chart found within Chapter 15, Section 15, Tax 6. If the service member is getting BAH and that money is not being taken directly out for housing, look at the column all the way to the right to calculate how much you owe. If you are living in on-base housing, look to the middle column. Under no circumstances can the Marine owe more than 1/3 of his or her gross pay. Gross pay is BAH plus base pay and nothing else. Marines owe this amount unless one of the following is true. Number 1, that the gross income of the spouse exceeds the gross military pay of the Marine, including allowances. That Marine still has to pay child support, though. Number 2, interim financial support has been provided to the spouse for a continuous and uninterrupted period of 12 months. That Marine still has to pay child support, though. Number 3, if the Marine has been a victim of substantiated abuse by a spouse seeking support. Remember that Marine still has to pay child support. Number 4, if the Marine is paying regular and recurring obligations, such as rent or consumer debts of the family members requesting support of sufficient magnitude and duration as to justify a reduction or elimination of support-specific requirements. For Navy personnel, MILPERS Man, Section 1754, TAC 030, is what you look to for support requirements. There is a chart on page 2. In this case, the support requirements are also a percentage of gross pay. In this case, gross pay is also BAH plus base pay and nothing else. Do not include BAH if all of your money is going towards base housing. Then it is just base pay. Exceptions to the support requirements in the Navy include a waiver for support of a spouse but not children on the basis of evidence of desertion without cause, physical abuse, or for infidelity on the part of the spouse. Check the regulation for procedures on how to request this waiver. For all services, it is important for a member to subtract indirect support, such as credit card bills, cell phone payments, car payments, etc., from the amount owed by the service member. If the service members fail to provide adequate support to their families, for the Marines, you can be subject to the UCMJ for violations of orders. All service members can be subject to administrative action and having their BAH with dependents taken back for times of inadequate support. The reason that service members get BAH at the dependent rate is because it is expected that they are supporting their families. If the service members do not support their dependents, they don't get to keep their BAH at the dependent rate. Also at stake is security clearances and good reputation. Just some things to keep in mind. If you as the service member are confused about how much you owe, or if you as the spouse are not receiving support, please go to your local legal assistance office. Second topic that I will cover. Number 2, base housing considerations. Oftentimes, military families live on base, and this makes things a bit more complicated when it comes to getting a divorce. It is important to look up the base order for where you are stationed and where you are living. But on Marine Corps Base Hawaii, Kaneohe Bay, it is base order P11101.35B. It's section 5005 that discusses early termination of assignment to quarters due to reasons other than PCS. These include divorce and physical separation. It states that military members or their unit commanders will immediately notify the landlord of any changes that will affect eligibility. These changes in eligibility include if the service member moves out, like back to the barracks, or if the spouse moves out, or from the date the divorce decree is filed. At that point, the remaining persons will have usually 30 days to leave the house. If the service member has custody of the kids for more than 6 months a year, and they can prove this either via separation agreement or court order, then the service member may stay in the house in most cases. There are exceptions to these rules, so if you have questions, go to your local housing office and tell them about your situation. The phone number for Marine Corps Base Hawaii Family Housing Office is 808-257-1257. If you are currently a Forest City resident, you must inform Forest City of any impending changes in dependent status and your intent to vacate the home. Please call the Resident Services Office at 808-839-8700 for assistance. 2 important things to remember are, 1, you may need special powers of attorney to work with the specific housing office, so ask them what they require. And 2, once the assignment to quarters is terminated, if the service member is restored to receiving full BAH with dependents, then the support requirements will change. So check the policy about support that applies to your service. Section 3 on early return of dependents. In Hawaii, military members can utilize the early return of dependents process, also known as ERD process, as a way for the government-sponsored dependents to have the government pay to send them home early as a result or in anticipation of separation or divorce. This includes airfare, household goods, and in some cases, even shipment of your POV. The process begins when the service member goes into his or her S1 shop and informs them that he would like to initiate the early return of dependent process, usually with an administrative action form. A successful ERD can also depend on the 2 parties agreeing on how they are going to split up the property and how the custody of the children will be arranged. That is why open, honest communication is vital to the success of the ERD process. Spouses of service members can also initiate the ERD process by contacting the Legal Assistance Office. Section 4, Other Considerations. I will now cover some extra considerations that it's important to understand while going through this process. 1, remember that you are not officially divorced until the judge has signed the divorce decree and it has been filed with the state. Until then, the service member is not permitted to begin relationships. Otherwise, the service member will be committing adultery, a crime punishable by the UCMJ. That means even if the service member's spouse has left, and even if the spouse is seeing other people, the service member cannot see other people. That also means that the service member owes support to their spouses and children until that divorce decree is filed with the state. From there, the support requirements depend on the divorce decree. Number 2, remember to go to IPAC and change your SGLI, or your Personnel Services Department. Otherwise, it will go to whomever is named in your SGLI. Number 3, also let IPAC or the PSD department know about changes in your dependency, as it will determine the amount of BAH you're entitled to. If you are ordered to pay child support, let IPAC know and give IPAC personnel your court orders so that they may apply the appropriate BAH amount. Failure to inform IPAC or PSD about changes in your dependency will result in the government withholding your pay until it gets back the extra that it paid you, if it came to that. Number 4, go into the Legal Assistance Office and change your will. Otherwise, even if you remarry, however your original will was drafted is how it will be distributed. Number 5, under the Service Member Civil Relief Act, No judicial or administrative actions can be taken if it appears that the service member's ability to defend his or her interests will be hampered due to military training or deployments. Therefore, if the service member is deployed or set to deploy within the next few months, the service member could request a stay in custody or divorce proceedings until he or she can better defend his or her interests. If you still have any questions, please go to your legal assistance office. This includes for topics such as support, non-support, custody, separation agreements, and retirement considerations. This is also if you are having trouble enforcing any of the topics covered in this video or the standard Hawaii divorce video. Thank you.